Hello there, Dr. Bechtel here with a lecture on divorce procedure, specifically talking about drafting an answer to a petition for dissolution of marriage. We use the term dissolution of marriage instead of divorce, although it's hard not to use divorce, but I do like to try to use the proper vocabulary. All right. So the purpose, well, there are actually two ways that a petition for dissolution can be responded to. So this is an important concept that you may have learned if you've taken civil procedures courses yet. One thing to recognize is there's such a thing as a response, and you need to be careful using that terminology. It is okay under Florida rules to file a notice of appearance, and the purpose of it is different from an answer. So anytime at a law firm, if you're asked to do a notice of appearance, do be sure that you pay attention to time deadlines that come about. So, for example, you wouldn't be asked to file a notice or to prepare a notice of appearance unless there's been a petition filed and probably served. There's notice out there that it's been served, or maybe it hasn't been served. But from the point of service, it's 20 days to answer the complaint, or I'm sorry, the petition. And as such, it's very important that you keep a really strong date system, tickler system, whatever you want to call that, depending on what the status of the dissolution of marriage petition is. It's been filed. There are 20 days left to answer. A notice of appearance will not, as you're going to learn in the first 3 slides here, will not protect the defendant from receiving a default judgment in the event that the petition for dissolution does not get answered. All right? So, first and foremost, make that your top priority to keep track of dates. It's so essential. So why would you file a notice of appearance versus an answer? Well, one other piece of history from my experience has been I was rarely asked to do a notice of appearance in either a dissolution or a civil case. The times when a notice of appearance was brought to me to be prepared was maybe when there was a question about full representation in the case. Attorneys will sometimes do like bundled service, or it's not called bundled. It may be called bundled, so I apologize if I'm not using the correct terminology there. But basically disaggregating the types of services that are available to a person who is retaining a lawyer. Anyway, a notice of appearance is a way to protect communication between the petitioner, which is in the family law world, we use petitioner instead of plaintiff. And so I'll stop there so I don't get too rambling on, but the main idea here is in a notice of appearance, you're going to establish the representation, or if you're the respondent, also in civil world we call that that person the defendant, you're establishing that you're joining the case. But it does not equal an answer. I guess that's just where I need to stop and stop rambling. So it can establish representation, it does, and the attorney or self-represented party basically joins in the case. It protects communication. Communication comes from opposing counsel. Communications can come from the court. And so an attorney of record is on in the system, if you will, of the court that explains that there is an attorney involved. Attorney may not have filed an answer yet. Anyway, I do not have very many examples of doing a notice of appearance. I just don't, because it mostly starts on the respondent's side. It mostly begins when a petition is filed and served on the defendant or respondent. So establishes some communication and protects that communication. And there is a form for it. It's in the Florida Court Rule, Form 12.903B or 12.903C22. And I apologize on this slide. This was designed by ChatGPT, which I really liked it, but I could not get Copilot, to change that C with a parenthesis, a closure of the parenthesis before the 22. So anyway, it said it did. It kept saying I have. I'm like, no, you haven't. And I don't know how to fix that. So anyway, it also provides opportunities for there to be mandatory disclosure. So if there isn't an attorney of record for the respondent, it's not very likely that the petitioner's attorney is going to be giving up mandatory disclosure documents, which are absolutely necessary in a dissolution of marriage case. And so you're not going to get anything that you need as far as information without something in the court file, such as a notice of appearance, to keep you informed of important issues, particularly where mandatory disclosure is concerned. And we'll talk about mandatory disclosure in a separate lecture, but basically there's financial documents that have to be provided in mandatory disclosure. That's what it means. If they're minor children, there's also a parenting course that has to be taken. So some of that parenting course information can be flowing, and maybe the respondent can get involved in the parenting course. It is also signed and notarized in front of a notary, and it is filed with the clerk of court. You could use e-filing if you are working with an attorney. If you're private, self-represented, then you need to consult with the courthouse and ask them how. There is a way for people to file electronically when they're self-represented. I'm not familiar with how that works, but I believe they do have a public depository way of people being able to be involved if they're in the public. But basically, the end game is just going to tell the court, I'm here and I'm ready to represent. And there is the Florida Family Law Rule 12.040, and Rule 12.505, and the Florida Rules of General Practice and Judicial Administration. In a separate lecture, I've mentioned this before, but there is a difference between the Florida Rules of Civil Procedure and the Florida Family Law Rules. And where the Florida Family Law Rules don't address something, such as a notice of appearance, you'll find that same area in the Florida Rules of General Practice and Judicial Administration. So, one other warning or reminder is to always be abreast of both the family law rules and the general practice rules. Now, an answer is a response to a petition for dissolution of marriage. Again, a notice of appearance is not a response to the dissolution of marriage. And on the next slide, I've got a comparison table. So this an answer that's components will have caption and case info. So if you've taken civil procedures or drafted a petition for dissolution, you know that the caption is the style, and it's governed by court rules, and it's going to be in the rules of judicial administration. Don't believe that the Florida Family Law Rules covers the caption or style, but that would be something to check my work on and make sure that you look at both to see if there are any likenesses or differences, or where one set of rules covers something that the other set of rules doesn't. This is so imperative to be an excellent legal professional, to realize that you may have other sources. So in the caption, it has some case information. There's a court heading. The court heading says what court it is, kind of an address to the court. It will have the party names and their designations, be it petitioner or respondent, and a place for the case number. And if you're answering the petition, then you would definitely have a case number by now. All right. So, just as in civil procedure, you're answering paragraph by paragraph. You're responding to each paragraph of the petition for dissolution of marriage. There are three possible responses in the Florida courts, and that would be to admit the paragraph allegation, to deny the allegation in the paragraph, or claim you don't have knowledge to respond. So those are the three. The jurisdiction and residency, you're going to look at your petition for dissolution and confirm that the court has authority. In order to do that, the person has to be in Florida for 6 or more months. And it's simple enough. What you'll see in a petition for dissolution is an allegation for it being irretrievably broken. So that's the standard in Florida, the legal standard for a petition for dissolution of marriage. So you're checking work as you're doing an answer. You're making sure that the allegations given do truthfully tell the story. And where they don't, you might deny that. Where they do have the correct allegations for marriage and grounds and parental responsibility and child support, etc., jurisdiction, debts, alimony, those are all going to be in the petition for dissolution of marriage. And so they'll make allegations in the petition for each of these areas. These are the jurisdiction, marriage and grounds, children, property and debts, and alimony and relief. Those are the primary areas that a petition for dissolution will cover. If there are no children, then the allegation will be there are no children born in this marriage, and you would reply to that in the answer, yes, or admitted or denied. All right, so at the end of a answer, there will be a signature of the respondent, and it's notarized, and then it's served on the other party. We do not have to go through a process server to serve an answer. And the answer is simply filed with the court, and notice of it, a copy of it is provided to the opposing counsel. In this case, if you're filing an answer, obviously the answer copy is going to go to the petitioner's counsel. There are forms. Again, we can rely heavily on forms in the Florida Rules of Civil Procedure, Florida Rules of Family Procedure, and 12.903B has the answer, 12.903C2, and again, this picture drawn by Copilot is very, very cool, but they have a hard time on Copilot properly citing to rules. But as we'll see in the next slide, 12.903C2 is a counter petition. All right, so quick discussion of the differences between an appearance and an answer. The purpose of an appearance is just, hi, I'm here, I'm ready to work on this case. An answer is to respond to the petition. And an appearance can be filed, as our textbooks often say, the appearance is filed first after service. Again, I saw that very rarely used in my world of work, even in civil procedures and in cases of civil litigation. But you will possibly work for attorneys that have a whole different game plan and like to do it for a particular reason. The timing of an answer must be filed. It must be filed and sent to the petitioner's attorney within 20 days. So, as we talked about in the previous slide, an appearance is filed by the attorney or a self-represented party. And, the attorney for the respondent would file an answer, or the party who self-represented would file the answer. And as I point out, the effect of an appearance is simply, I'm here, the door is open for any communications that you have for me, but it does not answer the petition for dissolution. Basically, the answer is the only way to prevent a default judgment. The parenting plan comes up a lot in some of these, and you want to make sure that you're working on the steps to get a parenting plan if there are children involved. So again, opening the door, hi, I'm here, versus beginning some dialogue with a response. Dialogue about the allegations versus I'm here. You can check the Florida Family Law Rule 12.040A, and don't forget that there is a corresponding Rules of General Practice and Judicial Administration, Rule 2.505, that comes into play. And again, there's some multiple rules to follow, and you need to carefully think through whether one or both apply and when. All right, so I can go past that. No, I don't. Okay. So importantly, just know also that, like what I pointed out, there are 3 ways where you to answer a dissolution of marriage allegation. It's allegation by allegation, admit, deny, or lack of knowledge. Each one is admitted or denied, or lack of knowledge stated, must be done for each allegation. And also realize that there are some procedural allegations like jurisdiction, residency, and then there's property and children and requests for relief specifically. Now, again, the form of the Florida Rules of Family Procedure 12.903B would be a layout and structural way to go about it. All right. Now, the other thing, when we're realize when an answer is being prepared, we're also learning about the case, what's involved in it. Again, children, finances, property, debt, that sort of thing. We're learning some basics of that from the petition for dissolution. But what we want to discover when we look at a petition for dissolution is to, before answering, make sure that they've cited the correct jurisdiction and residency, make sure that the petition properly asserts the grounds and the marital status, keeping in mind that irretrievably broken is a term used in Florida. That's the legal test for whether a marriage can be dissolved. And no fault comes into play here too, because fault doesn't matter. Now, it does matter when it comes to things like child support and parenting, shared parenting and that sort of thing, but that's in another lecture. I won't go into it here. Children and parenting, what are they asking for as far as parental responsibility and child support? Is that the same? How should you reply to that particular allegation? Property and assets will be listed, not in a lot of detail, but just a paragraph that explains that there is property, there are assets, and it might also tell the story in an allegation that some property is marital property and other property is non-marital property. So again, we're in strategy, thinking ahead, so it's not like just do an answer that just says what it says. You have to be really careful. Your attorney will help you do this. Debts and liabilities operate in the same kind of way as property and assets. And then if a petitioner is seeking alimony, there's a request for alimony. So you might deny that request, and it depends. Every case differs. You need to make sure you're working closely with the attorney who knows what the client needs. And then petitioners many times will ask in their petition for dissolution for the restoration of their former name, their former last name. And then, as in civil procedure, they have to ask for relief. There has to be a prayer for relief at the end, the wherefore clause, if you will. That's what we call that in civil procedures class, in my world anyway. And then a relief requested is responding to any other demands that might be demands, as in those things being presented in the petition, all need to be responded to. So be clear. Remember the 3 ways that you can respond: admit, deny, or state lack of knowledge, and then use the correct form for an answer versus a counter petition. All right, so procedurally, what happens is, again, we've got to meet the 20-day filing deadline, and we need to serve that answer on the petitioner, the petitioner's attorney, if they're represented, definitely to the attorney. You do this, we don't have to go through a formal service process, like through a process server or the sheriff. It can be mailed or hand-delivered or e-served by copy to the petitioner. Again, the Florida e-filing system does handle this if the petitioner is represented by an attorney, the attorney will get it. If the petitioner used the Florida filing system, e-filing system, then presumably the respondent will get it in one way, shape, or form from the court. So be sure to use the proper form. I've mentioned that a couple of times, and again, that C should be enclosed with parentheses. And Copilot does really cool stuff, but they're not always that accurate, and so that gives you a really good indication of how your responsibility is as a legal professional to be careful and noting anything that you see that's not right. There's mandatory disclosure. We cover that in a different lecture, but this is the exchange of required financial documents. These are set out in the Florida Family Rules of Procedure. It's an absolute necessity. It's called mandatory because it's mandatory. If there's a parenting course, that would also have to be handled to be compliant. And the signature and notarization, it needs to be signed in front of a notary. And a non-lawyer disclosure is required if a non-lawyer is preparing the answer. Now, I want to be careful that you know that this is not a place, if you're using the form from the court's cadre of forms, they always have a non-lawyer disclosure on it. Presumably, you're not going to be digging up those forms to do your job as a paralegal or other legal professional in the law office. You're going to probably maybe take those forms and convert them into something better because they are very basic, mostly. And but there's this spot on those forms at the end where it says if a non-lawyer helped you prepare these forms, they need to disclose that. You're a non-lawyer if you're working as a paralegal for a lawyer, but you don't do that disclosure, all right? That's only for folks that are document preparers and not working under the supervision of an attorney. That came about 10 years ago, maybe more. So as a paralegal, you'll probably be a notary, and you will probably be asking the client to come in and sign the document so that you can notarize it. And filing with the clerk, you file the original answer, you keep copies for yourself. In your electronic, you're probably all electronic in the law firms today. There's very little of what I did, and had a little folder, an ugly green folder. They are ugliest folders I've ever seen. And I had a house once. I bought it here in Florida. I still live in it. It's been repainted, but it was the same color as those ugly green folders. Just had to say that. And so the compliance and the next steps are, check into areas that require mediation, be a good case manager, and start helping prepare for trial. So the procedures are outlined in, so I see that chat Copilot did a little more spelling problems, but just remember for an answer it's 12.900B, the form is, and that's from the Family Law Rules of Procedure, and not the Civil Rules of Procedure. And 12.905 sub 5.2 if you are wanting to do a counter petition. So what happens when it's filed? So once it's filed, the answer, if it agrees with everything, if everyone admit, it's uncontested. Everything's good to go. You can proceed to a final hearing. If the answer denies any allegations, then it's going to be necessary to look at it as contested, and you may definitely need some mediation and eventually file a notice for trial. So in summary, the answer, as far as its appearance, will mirror the petition's structure with a case style, with or caption, whatever you want to call it, with a title to the document, and then an introduction paragraph followed by paragraph 1, 2, 3, 4, 5, 6, 7, Paragraph 1, admitted. Paragraph 2, admitted. Paragraph 3, denied. Paragraph 4, whatever it is. Your attorney will help you make those decisions. So you respond to each allegation quite clearly. Be sure to evaluate areas that are related to residency, the marital status, children of the marriage, property and debts of the marriage, and any kind of spousal support or alimony requests in the petition. Don't add new requests as the respondent. You don't want to add new requests. Instead, you would use a counter petition. And then follow the filing by watching your workflow. You'll file it, and then you need to follow up on service, and you need to make sure that you're acknowledging any kind of rules to notarize a document. Just knowing that there is a way the answer is going to shape whether the case is contested or uncontested. My references for this lecture come from the Florida Bar Chapter 3, Annulment and Dissolution of Marriage. It's under 23 Florida Practice, Florida Family Law. Really great resource if you can get access to Westlaw. You can get it there. And I usually provide that to my students in their learning management system called Canvas. And the book we use for this class is the William Statsky book, 2021, Family Law, 7th edition from Cengage Learning. And I really do like that book. All right. So that concludes this lecture, and thank you very much.